the advocate underwent some ISIS.
Item 14.
But I beg to appear on behalf of the petitioner. My lord, firstly, my lord,
The issue is as to whether after the appointment of the arbitrator by the Calcutta High Court,
yes,
the Tripura Commercial Court could have refused to refer the matter to arbitration. And I think the High Court is
my simple answer to this, my lord,
the High Court had appointed an arbitrator.
Without examining and considering the records that were lying before the arbitrator, which is completely a separate set of pleadings, my lord, before the arbitrator. My claim before the commercial court is completely independent of the dealership
All
agreement.
this can be argued before the arbitrator. Why should we entertain it at this stage?
The arbitrator, the Section 11 application on the basis of which the arbitrator has been appointed by the Calcutta High Court, my lord, is based on arbitration agreement.
Overall, the long and short of the story is that it can be sent to the arbitral tribunal. Why should be?
My set of pleadings in the commercial suit is completely independent of the dealership agreement. I am not at all governed by the dealership agreement. There is a basic misunderstanding on the part of the court, my lord. Secondly, my lord, without considering and examining the records lying before the arbitrator at Calcutta, my lord, the court could not have at paragraph 18, my lord. If your lordship kindly turns to page 15, paragraph 16.
Ultimately, what has the High Court done? The High Court has said that let the commercial remand order and saying that the commercial court should consider this.
Yes. Well, there could be parallel proceedings, but without looking into what was there before the arbitrator, the set of claims that were completely different. And my claim before the is a money suit, my lord. It's a simple money suit. It's a commercial claim. It is not a case of claim and a counterclaim. My set of facts are completely independent of the dealership agreement. Paragraph 10 of the plate, my lord, that is a different set of facts. Secondly, my lord, the High Court had interfered with
who are you? Who are you actually? Who are you in the sense? Who is your client?
My client is the instant petitioner, my lord, who has filed the commercial court in the Tripura High Court, in the commercial division court.
You are the dealer. Yes. You are the dealer.
No. Yes, I am a dealer. I am a dealer, but not eminent.
Maybe you are saying that your claim is independent of the dealership agreement.
Yes.
Your status arises as a dealer under the dealership agreement.
No, that dealership
agreement says, please consider our order. It directs the commercial court to consider their order, appointing an arbitrator.
Yes. Well, the arbitration agreement, which is between me and the dealer, maybe, my lord, it's an alleged document, is not at all a document which is with my custody. I have specifically stated in my plaint that I have never seen, this document has never seen the light of the day. In that event of the matter, my set of pleadings in the commercial court could have been in the light of the dealership agreement.
All this has to be looked at by the arbitrator. All this
arbitrator is deciding on the dealership agreement. That is for the respondent. That is the claim of the respondent against me. My claim against the respondent is completely different, and my suit is a prior.
You heard your point. No, it has to be before the arbitral tribunal. But anyway, we are not directing it has to be sent to the arbitral tribunal. The High Court has merely remanded the matter, directing the Tripura Commercial Court to consider its order, Calcutta High Court order, appointing an arbitrator. That's all.
But this is where I join my issue, my lord. Just one way.
I heard you now. I think we've made access clear.
To say, my lord, the Calcutta.
In item 15, it is in my humble submission that the Honorable High Court has committed grave error in saying that the minor dispute was transferred to respondent number 1 because it was transferred without following the provisions of law, and according to me, it is void.
Before that, you have to answer why we should condone the delay of 170 days in filing the SLP.
My lordship, because the petitioner was not knowing that there is a limitation in filing the SLP in the Supreme Court, and the advocate who was dealing with the matter in High Court was
on the ground of delay. Yes, thank you. Item 16.
My lordship, may kindly consider as soon as we got the matter, we got it filed. My lordship, may kindly consider, because the petitioners are also very not very poor. My lordship,
they have been in possession of the mine for the last 50 years.
But my lordship, that transfer was illegal. My lordship, that was
not a case for injunction. The High Court says that somebody who was in possession of a mine for 50 years, they can't be now injuncted like this. So, though we are dismissing, we can say this. We can even say this. Though there's a delay of 170 days in filing the special petition, we have also examined the correctness of the impugned order on merits and find no reason to interfere with the order. The special petition is accordingly dismissed both on the ground of delay and on merits.
My lordship, one last.
That's better. So that's like item 16.
blacklisted issuing any show cause notice and contrary to the terms of the tender itself, if my draw your lordship's attention to page 98.
The cancellation maybe. Learned Senior Counsel appearing on behalf of the petitioner submits that the petitioner was blacklisted for a period of 3 years from participating in the works of in the contracts of the municipal corporation without a notice to show cause being issued. Issue notice confined to the above aspect,
Lordship.
returnable on.
Lord, we are only requesting for a stay, Lord, because I won't be in a position to participate in any of the auctions, my Lord.
We'll make a short notice.
Lordship.
Oh, I see.
Lordship.
It's a due process.
Obliged.
So 17 number of petitions have been disposed of by the High Court. All the matters are not listed today. They pray for a one week time.
But there's a 174 delay, 174 day delay here.
No, as far as the first matter is concerned, there is 74.
As per my
174 day delay.
But in other matters, it is not there, man. In other
174.
yes, but in other matters, the delay is not too much, man. Kindly see, man. In some matters, it is
17. How many matters are there on 17?
in total, there are 8 matters, 7 matters, man. All the matters are not listed today, man. It will be taken after a week, man.
You can get your other matters. We'll dismiss this on the ground of delay.
Kindly see, man.
How can the state keep on saying that, look, there are other matters where there is no delay, therefore condone.
I'm not saying, kindly take up all the matters together because that's what delay part is concerned.
We will keep those other matters. We'll dismiss this on limitation.
Kindly take up this.
Limitation applies equally to everybody. And I think state governments in India now must be absolutely alert. And merely because it is a state, the government officers cannot just sit.
As per my
And,
report,
allow.
74, my lord.
And it's serial number 37, there's 74 days delay. We'll look at that matter independently. When it reaches, we'll take it up. This one we will dismiss on the ground of
No,
limitation.
my lord, I'm just saying that we'll take because on the technical ground, kindly see, my lord. Technical ground, my lord, they have to more than 3 or 4 crore rupees, my lord, kindly see. They have to pay more than 3 or 4 crore rupees, my lord, kindly see.
7 reaches. We'll see what the merits.
All the matters are not listed today, my lord. Therefore, I'm saying if you've taken after a week, my lord, all the matters, my lord.
How many are there?
In total, there are 8 matters, my lord. 3 or
Like give the number to the numbers.
yes,
to the
I will put the numbers, my lord.
list together with so and so
On Friday, my lord, next Friday. In the meantime, if there is defect, I will put the defect all them.
item 18
But it's on Friday, man.
next Friday.
This is a really piquant and unjust situation where I can't appoint an arbitrator. The matter is under litigation. Their appeal has been remanded by this honorable court to the High Court because it was earlier dismissed as non-maintainable. So the arbitration award has been set aside as being perverse at my instance.
The arbitration award was set aside by the single judge.
Section 34 judge.
I think Justice Dhanuka's judgment.
That's right.
We had dealt with this.
Justice Baldota's judgment.
Justice Baldota's judgment. There was a similar case which just came a few days back where there was the division bench set aside Justice Baldota's award on the
ground of perversity.
On the ground. What happened in the single judge?
No, thereafter, after the award was set aside on the ground of perversity, they filed a Section 37 application, which was dismissed as non-maintainable. Then they came to this honorable court. This honorable court found the appeal was maintainable and therefore remanded it back
to the division bench.
To the division bench, and that matter is still pending. Though we have made requests. And this honorable court had also directed expedition. That matter is still pending. When, therefore, this matter is still pending litigation, and the situation is that a perverse award against me has been set aside behind my back. 2018, they enter into a development agreement with respondent number 3. This is not disclosed. It is disclosed for the first time in 2023. Where, when I discover by chance that a huge construction is being put up, I move an application.
Mr. Ramchandran, what is the investment by your client?
The investment by my clients is 22 lakhs in a matter of 1.5 crore at that time. The amount should not matter at all, my lords.
course,
That was the
because,
initial payment.
You know, if a construction has taken place,
With respect.
and now you have invested about 22 lakhs, the
He has
High Court
paid
seems
8
to
lakhs,
be-
my lords. The respondent number 3 has paid 8 lakhs. It can't go by the
High Court
figures.
seems to have also been impressed by the fact that now impeding the development, the tenants on the property who are waiting for being
With
rehabilitated.
respect, my lords, with respect, those tenants who are part of the original bungalow, it's not some resettlement scheme. It is a bungalow which is being demolished and a 15-story structure is being put up.
The award against you in the arbitration, right? The award in the arbitration. What is the actual award in the arbitration which was set aside?
The award was that I'm not entitled to specific performance and I'm not entitled to damages, both of which have been set aside because the award has been held to be perverse. So the matter is at large and I file a fresh Section 11 application for the reason now that this third party has come. This third party seeks to get impleaded in that appeal. And I can't appoint a Section 11. Award was that my claim was dismissed. My claim was against his reneging on the 2005
So your claim
MOU.
for essentially for specific performance
Lordship.
or implementation of the MOU, that was rejected by the arbitrator. The single judge set aside the award and just set aside the award simpliciter.
simpliciter on the ground of perversity, but set it aside.
Right.
Therefore, fresh arbitration has to start. In any case, a fresh arbitration has to start. Immediately after the appeal was dismissed by the Bombay High Court, I filed a Section 11 application for fresh appointment of an arbitrator.
The appeal is by the other side, of course.
The appeal by the other side. When that appeal was dismissed, I filed a Section 11 application. But then this honorable court remanded the matter back to the High Court. So logically,
Even assuming that ultimately in the appeal, the award is affirmed, you still have recourse to a fresh Section 11.
and that is not being allowed by the impugned judgment. That is what is not being
They have
allowed.
created third-party rights in the meantime.
Lordships, and they have created third-party rights. And when a fault is being found with me,
We'll have to consider this because you have been non-suited even on your
Lordship,
Section
please.
11. Section 9 or something, we may or may not be with you. but-
Section 9 minutes, my request is this. If behind my back, this agreement is entered into
Mr.
and
Ramchandran,
not disclosed to the court,
You're also a very big builder in Mumbai.
Lordship, please.
There's nothing behind your back. You see the whole construction coming up, and you said a big building is
I
coming back.
happen
Nothing
to
is behind your back.
see it because I was passing that way. I'm not traveling on all the roads of Bombay every day. Minutes. I'm not traveling on all the roads of Bombay.
This is
every
not
day.
by this.
On
explanation
Section
is
9,
not
minutes,
there.
if your lordships are
But on
issuing
Section
notice,
11, perhaps you have a point that at least your remedy under 11 can be kept open, depending upon the outcome of that appeal. Perhaps we'll see.
on Section 9, my only limited prayer is this,
We'll-
minutes,
we'll-
as your lordships issue notice, let them not create third-party rights in favor of buyers. Let them not create.
We are issuing notice. We'll make a short notice.
Lordship.
We don't want to issue an interim order without hearing them. Serve Dusty and come. We'll just rise, members of the bar will rise because our distinguished colleagues from Brazil have to go around the court and look at the facility. We just rise for 2 minutes and
Before the learned visitor, my lords, rises with your lordships, I thought an anecdote, seeing your lordships encouraging a junior a few matters back. 48 years ago, my lords, in court number 2, Senior Justice Chandrachud was the presiding judge, and a 2-month-old lawyer, namely yours truly, was appearing before him, shaking with nervousness. And Senior Justice Chandrachud looked at the appearance slip and said, "Yes, Mr. Ramachandran," which gave me such confidence that I was able to argue a useless matter for 5 or 10 minutes. So I was reminded of that day, Milord. Sorry,
Thank you, Mr. Ramachandran.
But can I request, Milord, for Dusty in addition, Milord, so that it comes in 2 weeks,
We
Milord?
just told the court master it will be served dusty and after 2 weeks.
And no third-party rights, Milord, in the meantime.
That's why we are giving you 2 weeks. Thank you.
Lordship, please.